Hi, and welcome to Overview of Copyright for Creatives. I'm Tamara Coffey, the Arts Program Branch Manager with the Kentucky Arts Council. The Creative Industry Summit Series is a collection of webinars and online workshops that focus on the business of art with topics for artists, arts organizations, educators, teaching artists, community groups, and more. To see a listing of upcoming webinars, go to our website at artscouncil.ky.gov. Most of our webinars are recorded and can be viewed later on the KAC YouTube channel. While I have your attention, please join us in 2 weeks for the Kentucky Crafted Market on March 7th and 8th at the Kentucky Horse Park. During this webinar, please add your questions to the Q&A. Refrain from including any personal information or asking questions that specifically address an issue you're experiencing that might not apply to others watching the webinar. Specific questions should be addressed to Jeremy by contacting him directly or by applying for a Kentucky Peer Advisory Network consultancy when the application opens this summer. Jeremy is one of our KPAN advisors, and you can request his assistance through that program. About Jeremy. The law practice of Louisville attorney Jeremy Beck is focused on the arts. An active composer of classical music, Jeremy is a graduate of the University of Louisville's Brandeis School of Law and earned a doctorate in music composition from the Yale School of Music. Awarded a residency at Copeland House in 2026, his music has been presented by New York City Opera, the San Francisco Ballet Orchestra, Center for Contemporary Opera, and the Louisville Orchestra, among others. Recordings of Jeremy's orchestral, chamber, and vocal music are available on the Numa, CISS, Innova, and Ablaze labels. You can find Jeremy online at artsattorney.net or beckmusic.org. Okay, Jeremy, we're ready for you.
Great to be here. Thank you, Tamara. Good morning, everyone. We're here to talk about copyright. And where I'd like to start is actually to talk a minute about the differences between copyright and trademark. Sometimes those get a little confused. So, just briefly, these protect different types of work. So, when it comes to copyright, and Mark, go ahead with these. When it comes to copyright, those copyright protects all different kinds of creative work, artistic work, that's whether it's in writing, visual art, music, film, and all kinds of recordings. Compare that to trademark. Trademark is very specific in that it protects words or logos that are specifically identifying the source of goods or services that one may be offering. Importantly, neither copyright or trademark requires actual registration. Trademark comes into being through actual use in commerce, and copyright at the time of creation. And we'll talk more about that in a minute. But more rights are acquired through registration. So for work or for trademarks that you're using consistently or that are particularly important for the work that you are doing, it is always wise to pursue registration, particularly for trademark at the federal level. And for copyright, you can only register at the federal level. I'm continuing with that comparison. Again, copyright comes into being at the moment of creation, whereas trademark requires actual use in commerce. When you choose to register, copyright is to register a copyright is under $100, whereas trademark registration can get very expensive in the multiples of hundreds of dollars, depending upon how you're using your trademark and in what areas of commerce you may be using it. Finally, the length of time involved. Copyright lasts for the life of the author. And in this case, copyright law refers to all creators as authors. So it's life of the author plus 70 years. And then it goes into public domain. Whereas with trademark, that can be registered in perpetuity as long as the trademark holder continues to use it and continues to renew it. Okay, so let's go forward with what qualifies for copyright. And here I'm taking the text out of the statute, which is that it's original works that have to be fixed in some way in a tangible medium of expression. So it can't just be an idea, it has to be an expression of an idea. And the idea of something being fixed means that, for example, an improvisation, whether it's a musical improvisation or a dance performance, those can't be copyrighted until they're fixed. And the way they get fixed is through an audio or video recording. So an improvisation, a live improvisation, is not able to be copyrighted unless it's recorded in some way that fixes that improvisation or dance performance or a performance of a play, something like that. And this idea of utilitarian works, that, for example, is if a ceramicist creates a bowl or a pot or a cup, those elements themselves can't be copyrighted because they're simple, they're straightforward. The elements that could be copyrighted, however, are any designs that might be included on those particular works. So while the mug or the cup or the bowl itself could not be copyrighted, any design that's original, that is fixed on those works, those separate elements could be copyrighted. Okay, so copyright itself is not a single thing. And as this diagram shows, copyright is separable into different areas. So copyright means that one can make copies of the work, distribute the work, make derivatives of the work, display the work. And so when you own the copyright in a piece of writing or a piece of music or a piece of visual art, it means that you can separate that copyright and you can license or assign aspects of it separately. So that, say you have a piece of music, you might license the copyright to a publisher to make copies or distribute the work, or you might license or assign the right to make a recording of that work separately. Um, and so by retaining your copyright, and it's generally useful to think about licensing your copyright rather than assigning it, because if you license it, it means you retain control of that copyright. Whereas if you assign it, it means you're giving that copyright away completely. Um, but whatever you choose to do, that license or that assignment must be in writing. Anything having to do with copyright has to be in writing. But it's important to remember that you can license or assign aspects of your copyrighted work separately, that it doesn't have to be the whole thing. And that's why it's often referred to as a bundle of rights. Now I'm going to get into some specifics where we talk about copyright that refers to music. And in a little bit, I'm going to refer to visual arts. But just because we're talking about music or visual arts, many of these ideas translate to writing, to filmmaking, etc. So when you transfer or license your copyright, with respect to a license, you will want to make sure that you clarify whether that is exclusive or non-exclusive. So if it's an exclusive, say, publishing agreement, that means no one else can publish your particular song or piece of music. Whereas if it's non-exclusive, that means that one person, as well as another person, can move forward with publishing that music. And it really depends on what you negotiate with that third party. So the first kind of license we'll talk about or look at is a mechanical license. So this gives someone the right to reproduce and distribute recordings of your copyrighted composition or song in this case. The first time that one records a piece of music, they have to get that license from the holder of the copyright, which might be the songwriter or might be the publisher. But then subsequently, after a piece has been recorded, a license can be gotten from what's called the Harry Fox Agency, or there are a couple of other online organizations. There's Songfile, there's Easy Song, and anyone can then record the music after it's been recorded the first time. But they still need to get a mechanical license in order to do that. Now, with the sound recording itself, that always includes two copyrights. So if someone wants to use your recording, they will need to get both a sync license in order to use the musical composition, the song, and they will need to get what's called a master use license. So let's say that you're a recording artist, you write your own songs, and you record and release your own songs. If someone wants to use your song, use your music as part of a video or a film, they will need to get two licenses from you. They will need to get the sync license the synchronization license, which gives them the right to use the song, and they will need to get a master use license, which gives them the right to use the recording of that song. Maybe you have already licensed or transferred your copyright in the song to a music publisher, but you still have your own recording of the song. Then the person who wants to use your recording, they will have to seek the sync license from the publisher and get the master use license from you for the recording. If the recording is out on a label, they will have to get the master use license from the label. But the point is that any use of a recording of a song, of music by a filmmaker, they have to get two kinds of license. They have to get the sync license and they have to get the master use license. So continuing on now with the visual arts. So when a visual artist sells a piece of art, whatever it may be, and you can move it forward, Mark. Thank you. Whenever you sell a piece of your art, that sale does not include copyright. So you are selling the physical piece of work, but it does not give the buyer of that work any copyright unless you include that in the agreement. So what that means is if you retain your copyright, that means that you still have the right to reproduce it and to license it, whether to make copies of it, make prints of it, whatever the use may be, you retain that right unless you have included the copyright in the sales agreement or separately in some other agreement. Because again, copyright must be transferred in writing. So be very careful about that in your sales agreements or in your transfer agreements. I think it's always good to clarify that you retain copyright in the piece that you are selling, unless the agreement with the buyer is that you are including copyright as a part of that sales agreement. Now, under copyright, visual artists actually have a few more rights than other practitioners, other creatives, because the Visual Artists' Rights Act of 1990 states that, and this applies very specifically to a particular list. It applies to paintings and drawings, prints, sculpture, and then photographs when they are existing in a single copy or a limited edition. And so the rights that are included in this act include moral rights. And these are the rights of attribution and the right of integrity. And what that means is the right of attribution means that the artist has the right to claim or prevent authorship. No one else is allowed to put their name on your work. It's your work. And with the right of integrity, it means that no one can change or modify your work that would in some way be prejudicial to your reputation. And they cannot destroy your work. So if you've created a mural on a building, you've created a sculpture that's been that's site specific. That work cannot be destroyed or changed without your permission. And those are specific rights to artists under the Copyright Act. And these rights will last for the life of the author, and they survive copyright transfer. So we've been talking about your copyrights, copyrights owned by you, the creative person. But as we know, creative people will sometimes wish to make use of someone else's copyright. Maybe it's a quotation, maybe it's borrowing and adjusting some aspects of a photograph, whatever it might be. Let's talk for a minute about making use of someone else's copyrighted material. So, first of all, public domain. Public domain means that you can do whatever you want with it. And public domain is generally, not always, but generally what's been created and published before 1931. So it's always wise to be careful and confirm that something is actually public domain, because particularly as we creep further into the 20th century, sometimes there are questions. So the earlier something is, the less likely you would encounter any issues. For anything that's questionable, or certainly anything that's in copyright, get permission. Do not risk legal action. So, setting a text, adapting a work, adapting a short story for a film, whatever it might be, contact the rights holder. That could be a publisher, it could be a living creator, it could be the estate of the creator. Whatever rights that you seek, get that license in writing and have it clarify whether this is exclusive or non-exclusive. And in that license, try to address all the rights that you might seek, not just for the creation of your work, which is a derivative work, but to be able to perform the work, to record the work, to distribute the work, to display the work, to put it up on the internet, whatever it might be. So think about what it is that you wish to do with the work for which you're seeking permission, and try to get all of that in the written license, so you don't have to go back and ask for further permission. What comes up in this kind of discussion is often the question of fair use. So fair use Fair use is where you're basically saying, okay, I infringed this copyright. I did not get permission, but my use is fair. It's a fair use. But that's a defense. And that defense is always fact dependent. So if you use something without permission that's still in copyright, and you get a cease and desist letter, you can write back and say, well, but this is a fair use. But that's not going to be the end of it. That cease and desist letter, if they want to take you to trial over your infringement, they can do so. And by claiming fair use, you are agreeing, you're admitting, yes, I infringed, but this is my defense. So fair use is not always something that one should jump to first. Always seek permission if something is in copyright. Now, the thing that accompanies this is this idea of the work made for hire. So under the copyright statute, work made for hire means that if you're an employee, that the employer is the author for purposes of copyright. In other words, you're working for someone, you're working as an employee, you create something for your employer within the scope of your employment, the employer will be considered the author, the creator, for purposes of copyright. In addition, if you're not an employee, let's say you're an independent contractor, as creative people often are, you may still agree that the employer is the author and is holder of your copyright if that's in writing. So the contract would read that you are being hired not as an employee, as an independent contractor, but you're being hired under the work made for hire agreement. It's a work for hire, and that your employer will be, for purposes of copyright, the author, even if you get credit, is author and will hold the copyright. So you just want to be careful about that kind of an agreement. Now, under the statute, there are 9 categories in which work made for hire is automatic. And that's where it's part of a collective work, it's part of a film, translation. There's this whole statutory list. But again, even if you're not an employee, even if you're an independent contractor, the contract can agree that the employer is hiring you under the work made for hire agreement, so that copyright will be going to that employer. And in this context, the work made for hire, there are no moral rights under VERA for visual artists. And so you just want to be careful in your negotiations with someone who wishes to commission you to be clear that copyright is going to remain with you unless you choose to transfer that copyright in writing. And that's sort of my larger point in these presentations. which is to always get your agreements in writing. It's fine to have sort of initial conversations and to have initial email exchanges. But ultimately, whatever the deal is, whether it's a commission, whether it's a showing, whether it's a consignment, whether it's a performance, whether it's a recording, publish, whatever it might be, get your agreements in writing. That protects you and it protects the agreement. It protects what the deal is. Because then if there is a dispute down the road, you go back to the writing and it's all in one place. Here's what we agreed to. And if the dispute goes beyond just between you and the third party, and you have to get lawyers involved, then there's clarity as to what the problem is and hopefully how to resolve it. When clients come to me and they don't have an agreement in writing, or they've got just a series of emails, or they tell me what the agreement is supposed to be, that's where problems mostly occur in trying to solve whatever the dispute might be. So Tamara gave you my contact information at the beginning, but here it is again. And I don't charge for initial questions. I give free initial consults. So if you have a question, somebody sends you a contract and you don't know what something means, or you want to try to resolve a problem that's arisen in some relationship that you have that related to your creative work, reach out. If not to me, to another attorney who practices in this area, and try to get some insight into what's involved and what you may need to do to address your question or to address the issue. It's always best to try to get some answers up front rather than to try to untangle something after the fact. So we have some time here, and I'm happy to address questions.
If you have questions for Jeremy, please put them in the Q&A. Jeremy, Matthew Lidikin, I apologize if I'm mispronouncing your name, asks, what about using copyrighted material for educational purposes?
For educational purposes, of course, there is a carve out in copyright law, but you have to be careful about how you make use of that carve out. So if you are using material in class, if you're making, say, a handout, you're copying a poem that you're passing around, or you have a small choir, you should not allow those copies to leave. You should keep those copies, recollect them. Posting materials should not be posted in terms of the open internet. If materials are being posted, they should be posted in a way, and I'm sure that various school districts, if not individual schools, have their own guidelines and requirements for this. So those should be followed. But it's my understanding that posting on sort of narrow sites that require a sign in by students or something like that is one way to narrow the distribution so that it doesn't go outside the educational carve out that is given in the Copyright Act.
Guy Kemper is asking, is it possible to transfer copyright to visual arts to his estate? And how would he do that?
Absolutely. So, copyright is property, it's intellectual property. It's not physical property, but it can be passed to anyone in one's estate planning. Um, it would be important to clarify because copyright does not attach automatically to visual art. So, for example, a painter has a series of paintings that they wish to pass on to family members. The painter does not necessarily have to include copyright to everyone. Copyright in all of those paintings could go to a foundation or a museum or a trust. Um, so, but they could be attached. Maybe there's just one person to whom the artist wishes to pass along all the artwork that remains and all the copyrights associated with that artwork. Then, in that person's estate plan, they would just make that clear. So the overall general answer is yes, copyright can be passed down to whomever you wish to receive it. It just has to be included in the will or trust or whatever the estate planning documents are, just has to be included in that estate plan in writing.
Thanks, Jeremy. I have a question about generative AI. Um, what do you recommend for creating digital images such as in Adobe Photoshop or Firefly?
Um, well, anything, anything that any kind of creation that makes use of generative AI, the generative AI aspects themselves are not copyrightable. Um, courts have determined that anything that's been created by machine is not copyrightable. It's not considered an original creation. Uh, what one may do with that raw material, that may be copyrightable, but it really depends upon the scope of what one does that is um, creatively original outside of what has been created by the AI. And it's been determined that the the instructions, whatever is given to the AI for the creation by the machine, that does not constitute copyrightable material. So it really depends upon the scope of what one is creating and how one is creating it, what is original to that source material. And bear in mind that we are just at the beginning of AI and all of its implications, and likely there will be many changes in the laws going forward. So, this is where it stands right now, but that doesn't mean it'll be this way in a year or 10 years or what have you.
Okay, so I have a few questions here from Ann Hammond Prophet, all asking about getting her artwork copyrighted. She wants to know, um, does she need to hire an attorney to copyright all of her work, or would that be per piece, and how much would that normally cost?
Great question, and this applies really across the board. Um, there's a slight exception for photographs, um, but anyone can copyright their own work. You go to the website, which is copyright.gov, G-O-V, and there's a video that explains how the application process works. There's instructions. It's an online application that takes you through it step by step. Um, there are two types of applications. One is for an individual work. So let's say a single painting, and that fee is currently $65. And you upload as part of the application um, a photograph, a digital photograph of the painting. You can also upload a collection of no more than 10 paintings, and it has to be the same. So 10 poems, 10 songs, 10 whatever it may be. And that kind of group application, that fee is $85 currently. And you upload 10 digital photographs of the 10 paintings. So um, clients can do this for themselves. It's also something that I can do for clients if they wish. Um, but it's a fairly straightforward process. And with the instructional video and with the written instructions and the sort of step by step online application form, certainly this is something that um, people can do for themselves.
And she has another question. I think you might have answered this, but I'm going to put it to you anyway. When she's starting her website for her artwork, how would she keep her artwork from being copied?
That's tough because with the nature of the internet these days, um, people are stealing images all the time, and it's hard to police. Um, what you can do is watermark your images. That helps to dissuade theft. Um, and I'm not a computer person, but I know it may be possible to prevent downloading of images. I would speak to your webmaster, whoever is helping you put up your website. Um, and then if you uh, find that your images are appearing on commercial sites like Etsy or wherever it may be, all of those commercial sites have legal contact pages or links where you claim that someone is infringing your work and you request that it be taken down. And that's their obligation to do so. And otherwise, I mean, a lot of these thieves are operating overseas and are, it's just ubiquitous. It's very difficult to completely prevent um, the taking of one's images. And the best that one can do at this stage of the game is to try and dissuade that kind of theft through those approaches.
Okay, so I have a question about storytelling. Um, is it possible to copyright storytelling? Would that be, is it possible to copyright the stories themselves or a performance of a storytelling?
Okay, so if I think I would need a larger context, but I'll make up an example. If someone is telling a story that is their original story, if it's not written down, certainly if it's written down, it can be copyrighted. The performance of it can be copyrighted if there is an audio recording or a video recording, and that would copyright the material itself as well as the actual presentation of that material. If one has adapted something in the public domain, let's say, I don't know, a fable of some sort, that fable itself, because it's public domain, is not copyrightable, except to the extent that the storyteller has made some original contribution to that fable. But certainly their performance of it is copyrightable via an audio or video recording of that performance or presentation, whether that's live or it's a podcast or whatever it might be. If the story is based on something that is still in copyright, then the person would need to make sure that they have acquired whatever license they need to present their version of that copyrighted material. But again, that performance could be copyrighted in association with the license through their particular audio or video recording.
Doug Lohman has a question about registering copyright, or can you just write copyright and the date on your work to have it copyrighted?
Well, copyright comes into being as soon as you create whatever it is you've created. So I'm sitting at my desk. I'm writing. I'm writing a play. Copyright is immediate. When you distribute it, let's say you send it out to producers, certainly it's wise to put the copyright notice on the title page or somewhere conspicuous. And that copyright notice simply indicates that, yes, you are claiming your copyright in this work you have created. The point of registration is it's basically your first step if you ever needed to go to court. If you found that someone is infringing your copyright and you've sent them a cease and desist, they don't stop, and you really need to go to court, you need to sue someone for copyright infringement, you have to have a registration before the court will allow you to make that filing. Or rather, you'll make the filing, but the defense would have it thrown out because you're not registered. So you have to have the registration in order to get into court to file suit against someone who is infringing your work. So, no, you don't have to register your copyrights, but particularly for work that you may be sending out for wide distribution or work that is especially important to you, um, it's usually a wise idea to go ahead and register that copyright.
I think Guy Kemper is asking, what if he has a painting he did and translates it into a stained glass window? Does he need to copyright both the painting and the window?
That's a fair question. If the stained glass window is still fairly representative of the creator's original painting, so if I'm understanding correctly, the 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 creator created a painting and then created their own um, derivative work by taking that painting and putting it, using that image for the stained glass. I think the copyright of the original image is enough.
Okay, and one final question, and I think you've actually already answered this as well. But say there are two writers, for example, who are friends. One copies the work of the other. Both artists publish that work. What exactly does the original author need to do to further protect his work or to prevent that happening?
Excellent question. This goes for collaboration of any kind, whether it's in this context or any other. It is always wise to have a written agreement between collaborators, even if you're friends from when you were kids, even if you completely trust the other person. It is always wise to have a written agreement that states what you all are doing. So, in an agreement, it might be, well, person A is coming up with this original story, but persons A and B are going to publish this story together, and they are either going to both hold the copyright, or person A is going to hold the copyright and both A and B are going to collect royalties, whatever the deal might be. Have that written agreement between the collaborators that spells out exactly what it is you all want to do and how you are going to work with each other on a particular project. And that's going to clarify best who owns what and who gets what and who controls what.
Thank you, Jeremy. So That's all we have time for question wise right now. If you have questions that didn't get answered, remember you can contact Jeremy directly by using his website, artsattorney.net, or you can apply to the Kentucky Arts Council's Kentucky Peer Advisory Network and request to do a consultancy with Jeremy. Jeremy, as always, your presentations are excellent. We always appreciate your willingness to share your expertise. And as you, I'm sure, are well aware, everybody wants a friend who is a lawyer. So thank you for being that for us. This webinar has been recorded and we will post it to our YouTube channel in the next couple of days. If you want to rewatch it or share it with someone, please do that. We'll leave it up till the end of this year and then we'll remove it and have Jeremy come back and answer more questions, hopefully. In the meantime, watch our website for additional webinars, including Reading Between the Lines, Common Contract Traps in the Creative Sector on April 1st, and Finding Funding, Grant Search Basics on May 6th. And please join us at the Kentucky Crafted Market, March 7th and 8th at the Kentucky Horse Park. We'll have some of the Commonwealth's best visual and craft artists, live music, local food products, publishers, art activities for the kids, food trucks, and so much more. And thank you for joining us today. We look forward to seeing you again soon. Take care.